Westminster 911, what is the address of your emergency? Hey, what's going on there?
My daughter's missing. I guess she never made it to school this morning.
How old's your daughter?
She's 10.
Okay, what's your daughter's name?
Jessica Ridgeway.
And when did you last see her?
This morning when she left at 8:30.
Did she walk?
Yeah. And I checked her friend's house that she walked and they're not answering the door.
And you said that the school called, so they weren't...
And I work nights, so I slept through the call.
Okay, sir, sorry about that. We've got several officers on the way over to help you out, okay?
Long before this place became synonymous with fear, Westminster, Colorado was known for something else entirely: calm. A quiet suburb stretched between Denver and Boulder, where mornings moved slowly and neighbors recognized one another by name. It was a city defined by routine. Joggers along Big Dry Creek, families gathering near Stanley Lake to watch the sun drop behind the Rocky Mountains, children walking familiar paths to school without a second thought. This was the world 10-year-old Jessica Ridgeway lived in, and it was a world that, on the morning of October 5th, 2012, would never be the same again. Jessica lived with her mother, her grandmother, and her aunt in a modest home not far from Chelsea Park. Her parents, Sarah and Jeremiah, had been separated for years. Her father lived out of state, in Missouri, but despite the distance and occasional custody complications, Jessica maintained a loving relationship with both parents. At school, Witt Elementary, Jessica was known as the kind of student teachers rarely forgot. She was bright, engaged, and genuinely eager to learn. Classmates remembered her smile before they remembered her voice. She was the kind of child who raised her hand not to show off, but because she truly wanted to understand. She loved music and dance, often inventing her own routines at home. She adored animals, watched shows like Victorious and Wizards of Waverly Place, and once she set her mind on something, she refused to quit until she figured it out. Her grandmother would later describe her as energetic, determined, and almost always happy. On the morning of Friday, October 5th, Jessica woke up at 7:45 a.m., exactly as she had planned. Recently, she had asked her mother for an alarm clock. She wanted to wake up on her own, to feel grown up. That morning, she watched a bit of television, ate a granola bar, got dressed, and helped her mom peel an orange to take along to school. It was cold outside. Snow from the night before still clung to the ground. Jessica pulled on her winter coat, said goodbye, and stepped out the front door. She was supposed to meet her friends at Chelsea Park, just a 5-minute walk from home. They gathered there every morning before walking the rest of the way to school together. But that morning, Jessica never arrived. Her friends waited, then eventually continued on without her, assuming she was running late. But Jessica was never late. She never missed school. She loved it. By 10 a.m., teachers grew concerned and attempted to contact her mother. But Sarah had worked an overnight shift, from 10 p.m. to 7 a.m., and after walking Jessica out that morning, she went straight to bed. She didn't hear the call. The voicemail went unnoticed until 4:30 p.m. The moment Sarah listened to the message, panic set in. She drove past Chelsea Park, then to the school, then to the homes of Jessica's friends. No one had seen her. No one knew anything. There were no answers, only silence. That's when Sarah called the Westminster Police Department. For investigators, the realization came quickly and heavily. This was no longer a case of a child who wandered off. By 9:15 p.m., authorities believed they were dealing with a possible abduction. The Colorado Bureau of Investigation issued an Amber Alert, and within hours, the search exploded in scale. Local police, the FBI, firefighters, and volunteers flooded the area. Streets were blocked. Vehicles entering and leaving the neighborhood were photographed. Officers went door to door. DNA samples were collected. Hundreds of them. Firefighters used thermal imaging to scan Chelsea Park through the freezing darkness. Helicopters were requested, but grounded due to dangerously cold conditions. The weather worsened. Night fell, and the cold settled in. By morning, more than 1,000 people across 12 agencies were involved. over 4,000 tips would pour in. Jessica's purple ribbons, her favorite color, appeared tied to mailboxes and trees throughout the neighborhood. Inside her classroom, Jessica's desk sat empty. Her notebook was still there. Inside it, her homework was completed. On one page, a sentence stood out. "Don't play in the park alone. Be careful of strangers." Investigators faced two possibilities. Either Jessica had been lured away by someone she knew and trusted, or she had been taken suddenly, without warning. What seemed most unlikely was that she had willingly gone with a stranger. 4 days after her disappearance, Jessica's family stepped outside their home for the first time to speak publicly. Both parents denied any involvement. Both clung to hope. "She's my rock," her mother said quietly. "The bright voice of my little girl," her father added. "She needs to come home." But by then, the entire country was asking the same question. What happened to Jessica Ridgeway? As the hours passed, hope became harder to hold on to. Search teams worked relentlessly, both on the ground and from the air, but there was still no sign of 10-year-old Jessica Ridgeway. What had begun as a frantic search slowly turned into a grim waiting game, one that no parent should ever have to endure. Investigators ruled out any involvement by Jessica's immediate family early in the case. With no evidence pointing toward relatives, the leading theory shifted toward a stranger abduction. The idea that someone unknown had taken a child from her everyday route to school sent shockwaves through the community. The following day brought a discovery that no one initially recognized as crucial. A man living approximately 6.5 miles away in the Superior area came across a backpack discarded in his neighborhood. Along with it were a pair of glasses, a water bottle, and a piece of clothing that appeared to have been soiled. Attached to the backpack was a keychain bearing Jessica's name. At first, the man did not connect the find to the massive search unfolding miles away. He shared the discovery online, hoping the owner might come forward. It wasn't until someone else recognized the significance of the items that authorities were notified. For Jessica's family, the recovery of her belongings sparked a fragile sense of hope. The fact that the backpack had been left behind suggested movement, a possibility that she could still be alive. But that optimism was short-lived. The following night, authorities announced a far more devastating development. Human remains had been discovered near a park in the Denver suburb of Arvada, roughly 6 miles from Jessica's home. Maintenance workers had found a heavy bag along the side of a road and contacted police without opening it. Forensic testing later confirmed what no one wanted to believe. The remains belonged to Jessica Ridgeway. Only part of her body had been recovered, and at that stage, investigators were unable to determine the precise cause of death. At the scene, a wooden cross was also recovered. While officials did not initially disclose its exact placement, it was immediately treated as a significant piece of evidence. With this discovery, the focus of the investigation shifted. The search for a missing child had become a homicide investigation, and the priority was now to identify and stop the person responsible. The community of Westminster was overwhelmed with grief and fear. Vigils were held, candles lit, and purple ribbons, Jessica's favorite color, appeared throughout the neighborhood. Parents held their children closer, struggling with the realization that something so horrific had happened in a place once considered safe. As mourning spread, investigators intensified their efforts. They reviewed sex offender registries, analyzed cell phone tower data, and worked to establish patterns that might identify a suspect. At the same time, they uncovered a disturbing connection. 4 months earlier, on Memorial Day, a woman jogging near Carr Lake had been attacked from behind. A man attempted to incapacitate her using a cloth soaked in chemicals and dragged her toward nearby bushes. She managed to escape, but provided only limited details about her attacker. The assault had occurred alarmingly close to the area where Jessica was believed to have been taken. DNA collected from that earlier attack was compared to evidence from Jessica's case. The results confirmed investigators' fears. Both crimes involved the same perpetrator. With confirmation that a predator was operating in the community, authorities released a behavioral profile and urged residents to remain vigilant. Tips flooded in. Homes were searched. Thousands of leads were reviewed, and the pressure to identify the killer intensified. The breakthrough came when investigators publicly released images of the distinctive cross associated with the crime. A neighbor recognized it and contacted authorities with concerns about a teenager living nearby, 17-year-old Austin Sigg. The neighbor reported that Sigg owned a similar cross and had displayed a troubling fascination with death and decomposition. Investigators brought him in for questioning and collected a DNA sample. At the time, his explanation for his whereabouts appeared to satisfy investigators, and his DNA sample did not immediately return as a match. However, days later, media coverage revealed the confirmed DNA link between Jessica's murder and the earlier attack on the jogger. Around that same time, Sigg's behavior changed noticeably. He appeared physically unwell, emotionally unstable, and increasingly withdrawn. Within hours, the truth surfaced. Sigg confessed to his mother, who immediately contacted law enforcement. Authorities responded quickly, and a full confession followed. Investigators later learned that Sigg had been watching Jessica's route to school. He waited for the moment she was alone, positioned his vehicle to avoid detection, and abducted her in broad daylight. He restrained her using zip ties and transported her away from the neighborhood. According to his statements, the attack was not motivated by familiarity or personal grievance. It was opportunistic, random, and premeditated. From the moment of the abduction, investigators would later determine the outcome had already been decided. Jessica Ridgeway's life was taken by someone who saw her not as a child, but as an object. Her death marked the end of a short, joyful life, and the beginning of a permanent scar on an entire community. After abducting Jessica, the suspect drove her to his home. What happened inside those walls is known only through what he later disclosed to investigators. According to his account, he brought the child into his bedroom and attempted to create an illusion of normalcy. He removed the restraints from her wrists and turned on children's television programming, repeatedly assuring her that she would be returned home. At some point, Jessica was forced to change clothes. The suspect provided her with clothing belonging to him and altered her appearance by cutting her hair. He instructed her to turn away from him. Shortly afterward, he took her life. During questioning, the suspect acknowledged that his actions were driven by deeply disturbed impulses. While he denied committing a sexual assault, investigators noted that his own statements, combined with later findings, painted a far more troubling psychological profile.
I had never fully thought, and I had never actually fully planned through what I was going to do with it, what I was going to do, any of that. It just...
Well, when you went out that morning, Friday morning, October 5th, which was early in the morning, and you drove over to Jessica's neighborhood, what were you planning on doing that day?
I had the intent of picking up any female that came across where I was. That it didn't matter what time, where, it just anything.
So you were out, for a better word, hunting?
Yeah, that's the only word I could think of.
And did you know Jessica?
No.
Had you ever seen her before?
No, not at all. She was wrong place, wrong time. It was all random. I was... You
didn't stop the neighborhood or go over to that neighborhood and was looking for her?
Mm-hmm.
Have you been out before looking for somebody?
I had gone out before hunting, as you would call it, and I had never even remotely gotten close to anything or even been able to... Anytime that I would even see someone walking while I was out in one of those modes, my heart would just instantly start beating really fast, and I couldn't think straight. I don't know.
Was that some of the thrill that you got by going out and doing this? Was there a thrill aspect to it?
I've been trying to figure that out for a while now.
What followed demonstrated an extreme level of calculation and emotional detachment. Investigators later learned that the suspect dismembered the child's body inside the home, temporarily concealing portions of the remains before disposing of them in multiple locations. He later directed authorities to areas beneath the house where additional remains were recovered, confirming his involvement beyond any doubt. Evidence also showed that some attempts to destroy physical traces had occurred inside the residence, including within plumbing systems. These findings confirmed that Jessica had already been killed long before law enforcement began actively searching for her. As the interrogation continued, a critical procedural error came to light. The suspect's initial DNA sample, taken days earlier, had never been tested due to a clerical mistake. Once a second analysis was ordered, the result was definitive. His DNA matched biological evidence recovered from both Jessica's case and the earlier attempted assault of a jogger near Carr Lake. A forensic examination of the vehicle used in the abduction revealed broken plastic restraints consistent with those used to bind the child. Prosecutors later stated that the deliberate placement of Jessica's personal belongings in a separate location was intended to signal that she would not be found alive. Further investigation uncovered a long-standing fixation with death and human decomposition. The suspect had been studying mortuary science and had spent years consuming increasingly violent and disturbing material online. Digital forensic analysis later confirmed the presence of child exploitation material on his devices. Medical and psychological records showed that concerns about his behavior had been raised years earlier. His parents, who were divorced but remained involved in his life, had sought counseling and professional intervention. At one point, medical professionals urged stricter monitoring of his access to media and technology. Despite these efforts, the behavior escalated. The suspect was charged as an adult with multiple serious offenses, including murder, kidnapping, attempted murder related to the earlier assault, and sexual exploitation of a child. Additional charges were filed based on the material recovered from his electronic devices. Although he formally entered not guilty pleas, investigators and prosecutors emphasized that the physical evidence, forensic findings, and his own admissions formed an overwhelming case. Because he was 17 years old at the time of the crime, the death penalty was not applicable, but he faced the possibility of life imprisonment with parole eligibility only after several decades. Mental health experts who reviewed the case stated that there was no evidence of childhood abuse that could explain his actions. Despite growing up in a divided household, he had access to support and intervention. What stood out most to specialists was the absence of empathy or remorse for the victim. For Jessica's family and the wider community, the details of what occurred were almost impossible to comprehend. The crime was not impulsive, nor the result of neglect or chance. It was the product of long-developing fixation, secrecy, and failure to intervene decisively when warning signs appeared. Jessica Ridgeway's death marked the end of a short life filled with curiosity, creativity, and kindness. It also exposed the devastating consequences of ignoring behavioral red flags, both within families and within institutions tasked with preventing harm. This was not an impulsive crime, followed by regret. Investigators and prosecutors made it clear that the evidence pointed to intent and preparation long before the morning Jessica disappeared. Digital forensic analysis revealed that the suspect had actively searched for information related to abduction methods, chemical incapacitation, and locations where children were most vulnerable. These searches, combined with his admitted consumption of extreme and disturbing material online, reinforced the conclusion that the crime was planned. Authorities emphasized that the severity and complexity of the offense were unlike anything previously encountered involving a minor offender. The calculated nature of the act, paired with the effort to evade detection, demonstrated a level of danger that investigators believed posed a permanent risk to the community. While awaiting trial, the suspect was held in a segregated unit due to safety concerns. Nearly 1 year after Jessica left home for school, and just days before jury selection was scheduled to begin, he changed his legal strategy. He entered guilty pleas to multiple felony charges, including first-degree murder, kidnapping, sexual assault of a minor, attempted kidnapping, and sexual exploitation of a child. The guilty plea removed any remaining uncertainty surrounding responsibility for the crime. During sentencing, the court imposed the maximum allowable punishment under the law. A life sentence was issued for the murder conviction, followed by multiple consecutive sentences for the additional crimes. Although the suspect had been a juvenile at the time of the offense, the cumulative sentence effectively eliminated any possibility of release. The court made clear that no concessions had been granted. The sentence reflected the extraordinary nature of the crime and the need to protect the public indefinitely. Throughout the proceedings, the defendant showed no visible emotional response.
Thank you. Please be seated. Back to Secretary Council, President. Mr. President, Mr. Lord.
Your Honor, at this time, if Austin were to allocute, he would do that now, but I will inform the court that he is not going to. And that is undoubtedly in part due to his age and that the court granted expanded media coverage in this matter over defense counsel's objection. So Austin will not allocute. He will not make a statement to the court.
Well, he doesn't have the right to allocute, and I have the right to have me here. Without me being here, it's an open courtroom. So, is that his independent decision?
Yes, it is, Your Honor.
Do you want me to make any further findings? Do I need to make any further findings directly from Mr. Sigg as to that?
No, thank you.
You understand you have the right to say something if you want to, sir? Yeah. Thank you. Go ahead. Go ahead.
Your Honor, I'll address the legal argument of the sentence that we feel that is the only sentence that you may impose. And we submitted a memorandum of law to Your Honor, a memorandum of law in anticipation of sentencing, which is D67. It's presented as a memorandum, but at this point, I orally incorporate that into my oral motion and objection to any sentence other than a sentence to life with the possibility of parole after 40 calendar years. Your Honor, the district attorney, Mr. Sargent's argument, Mr. Madoran's argument legally, much of that includes speculation and categorical language. The argument that's fine, Your Honor. You're my audience here. Thank you, Your Honor. Your Honor, the district attorney attempts to place adult logic and reason onto a child's decision. But, Your Honor, the Supreme Court's Eighth Amendment's jurisprudence regarding juvenile offenders has shifted significantly recently by recognizing that juveniles are psychologically and developmentally different than adults and therefore less deserving of the most severe punishments. Your Honor, in Graham versus Florida, United States Supreme Court, they held that a juvenile lifetime without parole sentence for non-homicide offenses violates the Eighth Amendment's prohibition against cruel and unusual punishment. The court noted that a juvenile's diminished culpability required that sentences for non-homicide offenses must provide, quote, some meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. Later, the United States Supreme Court held in Miller versus Alabama, that case dealing with a homicide, the court held that for juvenile offenders convicted of a homicide, a mandatory, and I distinguish that, I recognize that, a mandatory juvenile lifetime without parole sentence is unconstitutional because a court would be unable to weigh pertinent evidence of the offender's youth in its sentencing decision. A juvenile's, and I quote, immaturity, impetuosity, and failure to appreciate risks and consequences are important factors in determining proportionality and diminished culpability. Your Honor, we get then into Colorado case law. And what we have to do is recognize...
But in your you're agreeing that this was the homicide case, it was discretionary and not mandatory?
The United States Supreme Court does not explicitly state that the court can't impose a lifetime sentence. But what we get into is the state of Colorado providing more strict or greater constitutional protections. And that is established, first of all, through the statutory language in 18.1.3.401, where, in this case, we're dealing with a Class 1 felony with a direct filing. The district court shall sentence the person, Austin, to a term of life imprisonment with the possibility of parole after serving a period of 40 calendar years. It's no guarantee to parole. When he hits after 40 calendar years, under the separation of powers, the parole board will make a determination when he's almost 60 years old whether or not he is appropriate. And the legislature gets into or creates this language because it does not impose upon you, Your Honor, as a trial court, the ability, or does not assume or speculate that you have the ability to look ahead to when Austin is almost 60 years old. You can't make a determination right now if he will be inappropriate for parole. The statute is clear that if he ever is able to parole, that he will then have lifetime parole. He is not just going to be released. He would be supervised by the parole board upon his release. Your Honor, we get into the Colorado case law. We first get into People versus Banks. There the court applied Miller versus Alabama, that standard, and held that the statutory mandate of lifetime without parole under which a juvenile defendant was sentenced was unconstitutional. So People versus Banks is establishing that a juvenile lifetime without parole for a homicide, applying Miller, was unconstitutional. They relied on Colorado's severability rules, and the court reduced the sentence to the longest sentence statutorily allowed in the remaining provisions, which was 40 years. We get into People versus Rainier, which I have attached to our memorandum of law. The court held there that a juvenile sentence of 112 years for a non-homicide was the functional equivalent of life without parole, and therefore was barred under Graham. The court found that such a sentence did not offer the meaningful opportunity for release that Graham requires, because Rainier would be eligible only after his natural life expectancy. So Rainier gets into the functional equivalent to a juvenile lifetime without parole, and finds that Rainier, dealing with a non-homicide case, was unconstitutional and consistent with Graham and Miller. Your Honor, if we marry these cases, if we marry them, Graham, Miller, Banks, and Rainier, Your Honor, would conclude that there cannot be, even in a homicide case, which is the matter before you, even in a homicide case, there can be no virtual, there can be no functional, there can be no de facto lifetime sentence for Austin. Yes.
Assuming, and I understand your argument, assuming there are other charges in addition to the homicide, and those other charges by statute or by case law are mandatorily concurrent, as has been presented. Are you saying that I cannot impose it? I said concurrent.
You said concurrent, Your Honor.
Consecutive, I misspoke. They're mandatorily consecutive. That means I cannot impose consecutive sentences.
Yes, Your Honor. The last page of my memorandum of law, I got into what I anticipated incorrectly that the prosecution would argue a people case close versus people, CLOSE, found at 48 Pacific 3rd, 528, Colorado Supreme Court from 2002. That case deals with if the court is able to look at a sentence in toto, a totality of a sentence, but close versus people was dealing with a proportionality review. And if Your Honor could look at it at not just the individual sentences of each convicted charge, but if you were able to look at them all together for purposes of proportionality. In that case, close, the court differentiates between a proportionality review and an Eighth Amendment cruel and unusual analysis. Your Honor must consider the Eighth Amendment cruel and unusual punishment in determining if a sentence combining every single sentence in each count would create a virtual or functional or de facto juvenile lifetime without parole sentence. The Colorado Court of Appeals specifically rejected the argument that close is binding in cases involved in juveniles and Eighth Amendment challenges to sentencing. In People v. Rainier, one of the cases I've mentioned to the court there states, and I quote, "We conclude that Graham effectively overruled close with respect to this particular class of defendants." The court may not impose a consecutive sentence because there's no way to do that with appropriately marrying Graham, Miller, Banks, and Rainier, because doing so would create a virtual, functional, or de facto juvenile lifetime without parole sentence, which, Your Honor, as applied, would be unconstitutional under the Eighth Amendment as cruel and unusual. Your Honor, for Austin, the language in Miller and Graham, Supreme Court, United States Supreme Court language, regarding the meaningful opportunity for release is important because it highlights the United States Supreme Court's understanding that juvenile offenders are different. Children are different than their adult counterparts and should be sentenced accordingly with that understanding. You know, I've provided to counsel and to you before the break statutory law, which I have filed it's under Title 13, and I may have given you my copy. Your Honor, what it establishes, if I may, Your Honor, yes. Your Honor,
Yes.
Your Honor, in Title 13, Statute 1325-102, it establishes a mortality table as evidence that is self-authenticating in modes of litigation in courts of justice, which we are dealing with here this morning. It states that for someone who is 18 years old, that they would live 59.6 years longer. Your Honor, imposing a lifetime sentence with the possibility of parole is nearly a de facto lifetime sentence. If you impose a consecutive sentence, you are getting into that dangerous area where marrying the United States Supreme Court cases and the Colorado Supreme Court cases would create a virtual lifetime sentence. Your Honor, I've provided to Your Honor filed as a submission of documentation in anticipation of sentencing, Department of Corrections treatment practices, which is D68. Your Honor, on page 4 of that document, we learn what is the Sex Offender Treatment and Monitoring Program of the Department of Corrections, their treatment policy. Their policy is that to the extent resources permit, offenders may be prioritized for treatment. A lifetime supervision sentence for offenders that are within 4 years of their parole eligibility date. What that establishes is that for someone who will have lifetime supervision, like Austin, he will not begin to receive therapy at the Department of Corrections until 4 years prior to his parole eligibility. He will be 54 years old when he will have his first opportunity for sex offender treatment and monitoring therapy. Your Honor, there is practically no parole board that will exist in the future that will send him out the front door, albeit heavily supervised through parole, after only 4 years of treatment. I say that because I don't want anyone, particularly you, Judge, to feel that a 40-year sentence will be in any way a free ride for Austin. Only after showing compliance, progression, and ultimately appropriateness for parole will the parole board allow him to parole. He will have to fully engage in the therapy. The nature of the parole board is one of self-accountability. There is a disinclination to release as they hold responsibility in part to their decisions and the subsequent actions of those people paroled. In People versus Rainier, the Rainier court, the Colorado court, recognized that 90% of those people eligible for parole upon their first opportunity for parole are denied. Your Honor, that is my argument, my legal argument, for why there should be no other sentence that you can impose other than a lifetime sentence with the opportunity for parole after 40 calendar years. Your Honor, I do have argument with regard to SVP finding that I'd like to do at this point, unless you have questions with regard to the legality of a sentence beyond the 40 calendar years.
Based on the offense decision evaluation that I received as part of the pre-sentence report, the adult sex offense pre-sentence. Their instrument said they had findings that I should make use not a sexual offense.
Your Honor, I think you've made it clear that you are going to deviate from that finding, correct?
I find the finding has no foundation in fact. So, yes, it will.
Okay, so you will deviate, you anticipate finding that Austin Sigg is SVP. Your Honor, then I do object to that in anticipation of that ruling. And, Your Honor, you pointed out that the pre-sentence investigation report finds no SVP, no sexually violent predator designation appropriate for Austin Sigg. There is a reason you ordered the pre-sentence investigation. Of course, statutorily, you did that, but there is a reason for that. 18.3414.5 subsection 2 establishes this. Based on the results of the assessment, the scoring instrument that was attached to the PSI, the court shall make specific findings of fact and enter an order concerning whether the defendant is a sexually violent predator. In People versus Rowland, R-O-W-L-A-N-D, at 207 Pacific 3rd, 890, Colorado Supreme Court, 2009, that statute requires the court to use the results of the SVP risk assessment to make findings whether the offender is an SVP. When we go to the actual scoring document, Your Honor, my position is that if the court is going to deviate from this scoring, you can't, or you will have the inability to rescore it in any way that will come to a conclusion of SVP. The PSI writers acknowledged, strike that, Your Honor. Your Honor, in the People's Memorandum, arguing that you should find SVP, they cite People versus Allen, found at 307 Pacific 3rd, 1102, Colorado Supreme Court, 2013, and suggest that the court there, in Allen, upheld a trial court's SVP finding despite a lack of recommendation based on the screening instrument, which is what it sounds like you are attempting to do. But it doesn't just allow for a very subjective, knee-jerk reaction by the court, making a subjective determination. In People versus Allen, it requires, after considering that statute, we hold and I'm quoting, that the trial court makes the ultimate SVP designation, but should give substantial deference to the screening instrument. A trial court that deviates from the results of the screening instrument must make specific findings on the record to demonstrate the necessity of the deviation. It wasn't just a general subjective determination, but in People versus Allen, the trial court rescored. They utilized that screening document to rescore, not to make a general determination that this case is bad enough for an SVP finding. Your Honor, if the court were to rescore and go through the risk determinations, which are in Part 3 of the SVP scoring instrument, that is on page 6 of 7 of the scoring document, it finds that with a score of 8 or higher, that is one of the requirements to a finding of SVP. Austin scored a 2, and he only scored a 2 because the age of the offender at the time of the index offense scored 2 if the offender was 25 or under. Had he been an age of majority, an adult, it would have only been a 1. He is far from the required 8 points. Your Honor, with regard to the sexually violent predator and such scoring, my argument is based on Austin's rights under 18.3.414.5, due process under the 14th Amendment to the United States Constitution, and Article 2, Section 25 of the Colorado Constitution. That is my argument, Your Honor, with regard to SVP determination and my objection to anything deviating from the scoring instrument. That's part of the PSI. I have something further, Your Honor. Your Honor, I want to be clear, just in case I've forgotten, that with regard to my memorandum of law, my argument that anything above a lifetime sentence with the possibility of parole after 40 years, that argument is based on Austin's due process rights, his right to counsel, equal protection, cruel and unusual punishment, compulsory process, and right to appeal under the 1st, 4th, 6th, 8th, 9th, 10th, and 14th Amendments to the United States Constitution, and Article 2, Sections 3, 6, 7, 10, 11, 16, 18, 20, 23, 25, and 28 under the Colorado Constitution. Your Honor, Austin, and I would posit that his family as well, are incredibly sorry for the loss that the community, and particularly the Ridgeway family, has experienced. With that said, Your Honor, and I said at the beginning this morning, you are my audience. And so I say this because I think you may understand, perhaps not the public listening in, that it has been an honor to represent someone who is considered probably one of the least of the brethren. Someone who most people in this courtroom may come to a quick decision that there is no redeemable value left in this young man, in this person, this child who pled guilty to a heinous act. Your Honor, the District Attorney's Office, their deputies, and defense counsel have litigated zealously and have engaged in a very zealous manner the adversarial process. In that, the family, both the Ridgeway family and the Sigg family, have always been very noble and appropriate to the court and to one another. It has been clear from the beginning of the proceedings that the Sigg family has chosen to wear purple as a sign of recognition of loss. Perhaps defense counsel wears purple on the inside, recognizing that loss as well. The thing about this, Your Honor, is that so much argument to you is an attempt to get you to understand through speculation and jumps in logic using an adult, fully formed brain of what happened. Wants to use your ability to reason and use logic and input that onto a child who did a very bad thing. That is not possible. You can try to understand. The defense has submitted mitigation. Mitigation not explaining away, but to the extent we can, using adult brains, understanding what took place. But the case law recently, the recent shift in case law, has recognized a deficit in children psychologically and developmentally. The court may not forget that in imposing its sentence. Your Honor, I humbly suggest that a sign of a great judge is one that recognizes the limits and parameters set by the people through the legislature. There should be a recognition of limitations of a judge's ability to understand the appropriateness of Austin being paroled. What I mean by that is that the court is limited in its ability to determine if Austin will be appropriate for parole when he is nearly 60 years old. The court would be presumptuous and speculative to assume at this early age, because of an act by a child, that that child would never be appropriate for parole. Your Honor, I submit that you cannot surely know if he, Austin, will be inappropriate for parole, and the court should recognize the separation of powers, which I've alluded to earlier in my argument. People versus Oglethorpe at 87 Pacific 3rd, 129, Colorado Court of Appeals, 2003, in dealing with an indeterminate sentence, stated this: the separation of powers doctrine prohibits the exercise by one branch of government of the powers that the Constitution vests in another branch of government. With respect to sentencing, the General Assembly has the inherent power to prescribe punishment for crimes and to limit the court's sentencing authority. The imposition of a sentence is a judicial function. Once a sentence is imposed, the executive branch is responsible for carrying out the court's mandate. The decision to grant parole to an inmate incarcerated for an indeterminate sentence is vested within the sound discretion of the state parole board. If you impose any sentence beyond lifetime with the possibility of parole after 40 calendar years, Your Honor, you are overreaching. You are going beyond the power that you have as a judge and are crossing over into the powers of the executive branch and the parole board. Your Honor, in paraphrasing Miller versus Alabama, there is great difficulty in distinguishing within a child whether the rare juvenile offender's crime reflects irreparable corruption or the child's offense reflects unfortunate yet transient immaturity. Your Honor, you are sentencing a child today. Life with the possibility of parole in 40 years is the only legal and appropriate sentence.
Sigg, this is your last chance to have a deal on something you need to, but I want to make sure you understand you have an opportunity together, right? To speak to me before sentencing. You understand?
Yes, sir.
Mr. Dorn, I don't need any response other than if you want to respond to the sexually violent offender argument that was made. I'm not requiring it.
We submitted factual findings supported by the record.
Thank you. I'm going to first address, this is a little bit out of order, I'm going to first address Mr. Lohr's concerns that I am limited and should be limited in my sentencing decision in this case. Given the facts and the aggravation in this case that's been presented to me, and I have had a chance to, and not a chance, I've been required to review matters that were submitted under Sigg in camera that were not published and probably should not be published, as to evidence in this case that would have been presented to a jury and would have been required to be presented to a jury if this case had gone to trial. Here I want to stop and thank Mr. Sigg for his pleas of guilty to all the outstanding charges. By doing that, sir, we relieve the 16 people sworn to try this case, court staff and the public, of reliving over the next 2 weeks the facts of this case and the experiences that Jessica went through on the day of her death. So I want to thank you for not having us go through that. However, given the facts of this case that I'm aware of and what's been acknowledged and admitted to, this case cries out for a sentence. I'm limited. I understand that I'm prohibited by statute from imposing what would be the most appropriate sentence in this case. If I had the discretion, I would not hesitate to impose a life without parole sentence. But I can't do that. I don't believe, though, that by imposing additional conditions that would violate the Eighth Amendment. My understanding of the law is, and it was based previously, that the Supreme Court, I'm not talking about the Colorado Supreme Court, the United States Supreme Court, has acknowledged that there are some cases where the facts and circumstances might be such that a juvenile, someone under the age of 18, could be sentenced to life in prison without parole. If that would be permissible under the 8th Amendment, I don't see where this court, in imposing a consecutive sentences that would expand, but that might modify the 40-year parole, would be a violation of the 8th Amendment. Those are my findings. Let me go now to the sexually violent predator issue. I'll note that under the instrument, that I've looked at the instrument, that one of the issues was that Mr. Sigg elected not to participate in the assessment. That's C, paragraph 3C, mental abnormality. And there are various criteria that they go through for that, for both the first part and the second part of that. Given the evidence that was presented, and given what I've seen in the evidence in this case, if that had been presented to the screener while this instrument was being used, as testified to by the doctor, I think that that would have been an aggravating factor for the scorer to go through this if they had that information and had the ability to have that information. There's some other matters here. They have one matter as to age of the offender restored to 2. The offender was known to the victim. No matter what he said, there was some evidence of the photograph and the way that he had the child dress to mimic her cheerleader's outfit, etc. The offender has not graduated from high school. If we give you a 0 on that, time of the arrest, if he did graduate score, did not graduate score 1, the definition of graduation excludes receipt of a GED unless the offender also attended any post-secondary education program, college, grade school, community college. Given this factor, as to the attending and the circumstance in this case, I question whether or not that should have been scored the way it was. 5, the offender has 1 or more adult convictions. Obviously, he does not, by his admission in this case, he offended and committed an attempted kidnapping for the purpose of sexual assault and murder about 4 or 5 months prior to this. That is not a prior conviction, but by his admission, it was a prior violation of a very, very serious crime. I don't know what the Court of Appeals would do, or someone else would do, if they're reviewing this instrument. If this instrument, given these facts, does not assess someone as a sexually violent predator, the instrument needs to be changed. It's inappropriate. As to the sentence, I'm going to go through numerous counts. Many of these counts are enhancers, crimes of violence, etc., that enhance the potential penalty. As to count 1, it's murder. To that count, I'm sentencing Mr. Sigg to life imprisonment. Under the current limitations I have by the legislature, he is by statute eligible for consideration for parole after 40 years. Please counts 3, 4, and 5 are also the murder counts. They merge into that count. Count 5, second-degree kidnapping. Mr. Sigg is sentenced to 48 years in the Department of Corrections. That's specifically consecutive to the sentence that announced for count 1. In count 6 is a crime of violence. He's admitted those only. Those as to count 7. That second-degree kidnapping, that, let me go to my notes on that. That was as I said, count 7, that's secondary kidnapping, that's a class 2 felony. That carries 16 to 48 years, as I was looking at. Mr. Sigg is sentenced to permanent corrections for 48 years on count 7. That's specifically consecutive to and not concurrent with the sentence I announced as count 1 and the sentence I announced as count 5. On count 9, that's sexual assault of a child. On count 9, that's a class 3 felony. Mr. Sigg is sentenced to 24 years to life. It's an indeterminate sentence. Minimum of 24 years, maximum is natural life. That's also consecutive to the sentence I just announced as to count 1 and count 5. Count 10 is a crime of violence. Count 11 is a robbery. That's he's sentenced to 5 years on robbery. That's specifically concurrent. That is not consecutive with the other counts I just announced. Count 16 has to do with the electronic jogger. On that, we acknowledged the penalty was up to 8 years and not 6 years when we started the sentencing hearing. He is sentenced to 8 years in Department of Corrections. That specifically consecutive counts 1, 5, 9, and all of the counts that he is sentenced on in this case. 17 is a crime of violence. 18 is sexual assault. I believe that is merged, and I find that merges with count 9. That sexual assault count merges with count 9. Count 19 is crime of violence. Count 20 is sexual exploitation. I believe that's count 20. That's count 20 is sexual exploitation. Count 21 is that sexual exploitation of a child. And count 22 is sexual exploitation of a child. I find that on count 20, he is sentenced to 6 years in the Department of Corrections. That's specifically consecutive to the sentence I announced on count 1, count 5, count 7, and all of the counts. Count 21 is sexual exploitation of a child. That carries 6 years. Count 22 is also sexual exploitation of a child, and that carries 4 years, 2 to 4 years. Those are both specifically concurrent with count 20 that I just announced. So all of those sexual exploitation charges will be concurrent with the 6 years I announced on count 20. Those are my sentencing as to those counts. Finally, I cannot emphasize as much as how this crime has affected the courts, how it's affected communities, and sure it's how it affected both the families. On October 5, 2012, Jessica Ridgeway left school at Whit Elementary at age 25. She never arrived. The search for Jessica was the most massive in the history of Wheat Ridge and Jefferson County. Hundreds of volunteers, in addition to police, fire, federal law enforcement agencies, and children, joined in the search for Jessica. And that occurred day and night, went on for day and night. October 10, 2012, the dismembered body of Jessica was found in an open space area west at the intersection of West 82nd and Quaker Street. On October 19, 2012, as a result of a tip, agents went to the Sigg home and took a DNA sample from Austin Sigg. On October 23, 2012, Mindy Sigg called the Westminster Police Department and reported that her son, Austin Sigg, had confessed to her he had kidnapped and killed Jessica. That same day, Mr. Sigg was interviewed by Detectives Lynch and Boatwright. Austin Sigg acknowledged that he was responsible for the kidnapping and death of Jessica and the kidnapping of a jogger at Pittner Reservoir on May 28, 2012. A jury of 16 was selected to try this case. It was sworn to involve the kidnapping and murder of Jessica. That was to start on October 3, 2013. The Kettner Lake counts were severed. Mr. Sigg entered pleas to all charges on October 1st, 2013. By his plea, he acknowledged his guilt and therefore spared the jury, families, and so forth of having to live through the last day of her life. Based on the work of law enforcement personnel, investigators, and the statements of Mr. Sigg, we know what happened. What still is a mystery and may never be understood is why an intelligent young man from a good home, good family, advantages, financial security, and love of his family, and good thoughts of his teachers, parents, and associates, decided to kidnap, terrorize, and brutally murder a 10-year-old girl. I've heard that from everyone. Why did this happen? We know this, we know that, but why did this happen? The only answer I can come close to in finding was stated by Chief Burke in his statement, and also referred to by Mr. Sargent in his statements. That was given to Detective Lynch and Detective Burke on October 21st, 2012. As I noted, the exact quote is as follows. I don't know about society because I've never really been that great with it, but I know that personally I am a monster for what I've done. I couldn't find a better word to describe evil than exactly what I've done. Evil is apparently real. It was present in our community on Friday, October 5, 2012. On that day, his name was Austin Sigg. It's my order that Mr. Sigg be taken by the Sheriff of Jefferson County by and transported to the Director of the Department of Institutions. There to be confined for what I anticipate will be the rest of his natural life in light of these sentences. You'll take it from here next.
We do have some housekeeping matters to address with you. So all right. You may be seated. What are the housekeeping matters?
Your Honor, I understand from your ruling that you have overruled my argument of law about the imposition of sentence going beyond lifetime with the ability to parole after 40 calendar years.
By making these 70 sentences consecutive as opposed to concurrent?
Yes, Your Honor.
That's what I've done. I've made them consecutive.
Understand. Your Honor, and also with regard to the sexually violent predator finding that you have made, I was objecting in anticipation. I do now formally object and incorporate my argument and law into that objection.
Your objection is noted.
Your Honor, we also have housekeeping matters with regard to motions filed by the prosecution with regard to restitution, cost of prosecution. And
you object?
Your Honor, we do object to the cost of prosecution.
File a written objection, please, and I'll take this up.
We do. Your Honor, then we have a matter of the district attorney's presentation in form of video that was presented yesterday to the court. We would like that made part of the record and submitted to the court.
I'll order that part of the record as for your video if you need presenting, or as for your PowerPoint if you need presenting. For the view.
To clarify, Your Honor, we do not object to the restitution requested by the prosecution. To date, if there is more requested, we reserve right to object.
The restitution request as proposed is ordered. Anything further? Housekeeping.
We assume the court is going to find the pre-sentence confinement as indicated in the pre-sentence investigation report.
It is what it is, correct.
And
I believe that I just pushed that away. I show pre-sentence confinement as of November 18th, 391 days.
That's acceptable to the defense.
We have a few more days. That was as of Monday, November 18th.
392.
Today, 392.
Yes.
Just to clarify counts 5 and 7, Your Honor, those are the two different kidnapping counts that the court said they were, because there's really one kidnapping, the court said they were concurrent with one another. And
They're both alleged kidnapping of Jessica, correct?
correct. There are two different theories upon which the enhancement of the one kidnapping.
They murders there.
Thank you. So they're consecutive to everything else but concurrent to one another.
Absolutely, that's what I thought it said.
Thank you very much, Your Honor.
Anything further, Mr. Wilson?
Nothing else, Your Honor.
You may take me back. You may answer this.
For Jessica's family, The conclusion of the legal process did not bring relief, but it did bring finality. They chose to shift their focus away from the individual responsible and toward preserving Jessica's memory and the impact of her life. The suspect's mother, who had made the decision to contact authorities after her son confessed, maintained that she did not regret her actions. In the years that followed, she sought intensive therapy and remained separated from her son, stating that she could not reconcile the person she raised with the person he became. Her grief existed alongside that of Jessica's family, recognized by many as a different but profound form of loss. Within the community, remembrance took on a visible and lasting form. Parks, playgrounds, and public spaces were transformed with symbols tied to Jessica's life, purple accents, personalized structures, and tributes created by classmates and neighbors. These spaces were not built to memorialize tragedy, but to reflect joy, kindness, and childhood. One of the most enduring legacies to emerge from the case was a rapid alert community program designed to assist in locating missing children within minutes. Additional initiatives were created in Jessica's name, including youth programs inspired by her interests and dreams. Years later, Jessica's mother welcomed another daughter. The presence of loss remained, but it existed alongside growth, memory, and continuity. Jessica's name, favorite color, and spirit remained part of daily life, woven into family traditions and shared stories. Her place was not replaced, but expanded into something that continued forward. Jessica Ridgeway's story is one of devastating interruption. A childhood ended during an ordinary walk to school. What should have been a simple moment of independence became the point where innocence was taken, and a community was forever changed. For her family, life continues one day at a time. The grief does not disappear, but it evolves. The cracks remain, even as strength grows around them. Jessica is remembered not only for how she died, but for who she was: curious, joyful, and full of promise. Her story endures as both a warning and a call to action. It reminds the world of what is lost when danger goes unnoticed, and what can be built when memory is honored with purpose.